Hi, my name is Chris Mays. I'm a Northern Virginia estate planning and elder law attorney, and this is our on-demand webinar for creating a Virginia estate plan. So in this video, we'll spend about 30 minutes or so going over the fundamental things that somebody looking to create an estate plan or thinking about creating an estate plan should start off with in terms of their fundamental knowledge, right? Specifically, what we will do is talk about what we're trying to accomplish. So when we're saying we're going to put an estate plan together, when we're working with an attorney to put an estate plan together, what specifically is it that we are trying to do, right? What are the goals that we're trying to accomplish? This is important because when we know what our goals are, we can create a very specific process for getting there. We can kind of avoid getting lost in the sauce, so to speak. And, when we know where we're going, we can formulate a very easy plan as to how to get there, and that's going to be very effective. The second thing we'll talk about is when we put together an estate plan, how do we do that, right? And what we'll see is there's the 5 most common documents that attorneys will use when we're putting together an estate plan. Now, this is not to say that these documents constitute the entirety of the various kind of documents people use in estate planning. If you've looked at the internet, I'm sure you've seen there's, dozens of different kinds of trusts, all sorts of complicated things out there. But a lot of times when we're talking about estate planning for most people, right, most regular people like you and me, there's going to probably be about 5 documents that we're really going to be focusing on. And you'll see that if you have sort of a basic understanding of these documents, it doesn't have to be a super technical understanding, but just a basic understanding of the documents and what they do, you're going to be ahead of the game when it comes to putting your estate plan together. Finally, we'll talk about, for clients who are interested, how you can work with our office, what we do in our process, and how we can help you work with an attorney to put your estate plan together, hopefully very easily and conveniently and affordably. So let's get started, but before we do, just a little bit about me and who I am. So I am a Northern Virginia estate planning and elder law attorney. I've been in private practice for about 19 years. For all of those 19 years, I've been working in family legal matters, helping clients navigate the legal system. And right now, about half of my practice is what I would call estate reacting, right? So that is where either clients don't have a plan, right? They've never put an estate plan together, or the estate plan that they put together, there are problems with it. So that can involve things like we may have to talk about guardianship and conservatorship. It can involve probate and sometimes estate litigation type issues, but sort of fixing problems that have come up because there was no planning or the planning we had was poor. The other half of my practice is the estate planning side. So that's where I work with clients to hopefully put plans in place where we avoid all of the problems on the other side of the house, so to speak. So I find those two parts of my practice mesh well together. When we spend a lot of time working with estate reacting cases, trying to fix problems, that knowledge I find is very helpful in helping to put plans together where we're trying to avoid problems. So that's who I am. That's where I'm coming from. And again, as part of this process, we're trying to use the experience of an attorney who's sort of been there, done that, to help you put a plan together where we can avoid a lot of the problems that can come up in this area of the law. So let's talk about what we're trying to accomplish, sort of the big picture here. I tell clients, the number one thing we do when we're estate planning is getting organized, right? I think it's the number one thing you can do to help your family when it comes to estate planning, right? You can have great documents, you can work with great attorneys, and, have all of that taken care of. But if everything's a mess, if nobody knows where you bank, if nobody knows whether or not you have life insurance, if we don't know where your retirement accounts are, if we don't know where the documents are, right, then a lot of the, most of the work you put into your estate plan isn't going to account for much. So getting organized is huge. It's something I really focus on with clients. And I think if we have to look at one thing, that's the single most important thing you can do to help your family in this area. The second thing that we do that estate planning is very important is transferring ownership, right? So the idea here, obviously, if we sort of break it down into very simple terms, is you own things. At some point, you pass away. Those things that you owned are going to be transferred to somebody else. And we're not talking about sort of simple things, right? We're talking about things that are very significant, right? Very complicated. So how a home gets owned and transferred, how retirement accounts get transferred. We're talking about transferring significant sums of money, things that you've spent a lifetime accumulating and that have a very complicated way of transferring. So when we do talk about transferring these assets, for example, with a house, there's a deed that is used to reflect ownership. Well, that's a very complicated document. If things aren't handled the right way, these transfers of ownership can fail, right? So we want to make sure that as we're transferring these documents that we meet all of the technical and legal requirements necessary to make the transfers valid. So that's the second biggest thing we look at. Working with an attorney here this is where the attorney is really going to be able to step in and sort of help you, make sure you're meeting all of the requirements to make these transfers valid. The next thing that we really spend a lot of time thinking about, and again, there's different families with different dynamics. No two families are going to be alike, but minimizing conflict. So if things are not organized, if the legal mechanisms that we're looking at to transfer ownership are not clear or not valid or not set up properly, we're going to create fertile ground for conflict, right? As I'm sure you can imagine, there are plenty of circumstances where people have disputes as they relate to, estates and estate administration, right? Disputes about the validity of wills, disputes about, were they these documents properly created? Were the people who created them of the appropriate state of mind, and things like that. So if we're not doing a good job of putting our estate plan together, we're going to create this fertile ground for conflict, and obviously that's not what we want to leave our family. So minimizing conflict, there's some very concrete steps we can take to make sure that we're not creating a circumstance where conflict can arise. And again, working with an attorney here is really going to benefit you. Like I said earlier, I know when I work with clients to do estate planning, it's bringing that experience of the actual conflicts I do have to deal with to the table to help clients say, look, you don't want to do X, Y, and Z because this is what is going to happen. Finally, another thing that we're trying to accomplish that a lot of people I feel sometimes ignore or just don't think about is incapacity planning. So most people, I think, are aware, okay, estate planning involves somebody passing away. Where do all of their possessions go? Estate planning also involves what happens if you're still alive, but you're not able to manage your affairs, right? So what happens if, because of illness, you can think of things like coma or whatever, but also age-related decline, cognitive decline, Alzheimer's, right? where you're just not able to manage your affairs, and you're going to need somebody to step in and do that. We'll see that there are different ways to do this. And so thinking about what these circumstances might be, how I'm going to have people step in, who those people are going to be, what are the documents or mechanism for how they're going to step in, how's that work? That's a very important part of estate planning. And again, having an attorney to help you put this together can be very beneficial. So let's talk about the 5 common documents that we use when we're putting together an estate plan. Like I said earlier, there's a ton of different types, especially trusts. There's a million different types of trusts out there. But for most people, most normal, regular, run-of-the-mill people, you're probably going to end up looking at something like these 5 documents, right? These are sort of the bread and butter of the documents that we as estate planners use. And I think even for people with very complicated estate plans that, we get into some of the more complicated trusts, you're still going to have this these fundamental documents in your plan, right? So if you're going to become familiar with documents, these are the documents to sort of have some familiarity with. So we'll go through them real quick. We have a will, right? So most people are familiar with wills. These are the documents where the will transfers property once the maker of the will dies. Most people, however, probably don't realize, we're not going to be necessarily transferring all of the property, right? When we use a will to transfer someone's estate at death, we have to sort of keep in mind that the will only transfers what we call the probate estate. So there are going to be certain types of assets, we call them non-probate assets, where those assets pass via a mechanism other than the will. Most commonly, these are going to be things like IRAs, 401ks, retirement accounts where we have beneficiary designations, and it's that beneficiary designation that transfers the asset. It doesn't matter what the will says, it matters what that beneficiary designation is. Likewise, we can own real estate as a joint owner with somebody else, and if that real estate passes via right of survivorship, it's that right of survivorship that's going to transfer the interest in the property, not the will. So even though we have a will, it's important to keep in mind a will probably isn't going to necessarily cover everything, and making sure that we have those other non-probate assets properly set up, to make sure that they fall in accordance with our overall plan. The other thing to keep in mind with a will is that all wills must go through probate. So probate is a process where the court formally recognizes the will. The court then supervises carrying out the terms of the will. But all wills, if we're having a will transfer somebody's property at their death, all wills have to go through the court. So that's something to keep in mind when we're thinking about how we're going to use a will in our estate plan. The next type of document that we will commonly see is a trust. Now, there are many different types of trusts. Usually, when we're talking about sort of the fundamental trust used in estate planning, we're going to be talking about a revocable living trust. But regardless, the basic idea is the trust, it's almost like a corporation. It's not a corporation, but it's similar in that just like a corporation owns assets, right? So Microsoft is a corporation. Microsoft owns real estate. Microsoft has bank accounts. So too can a trust. So usually when we're talking about a trust in the context of estate planning, you're going to have the trust set up, and that trust will own your assets. You'll put your assets into the trust. The reason a lot of people do this is because it avoids that probate process that is required with a will. That's one of the main things we look at, or one of the main benefits of a trust. There's other benefits as well, But you'll see that by avoiding probate, it can make it a little bit easier to manage the estate, right? Because now we don't have to deal with the court. We kind of do things on our own, and that can be a little bit easier of a process. We'll talk about that a little bit more here coming up, but that's just sort of a quick overview of what trusts are. The next document that we talk about is the financial power of attorney, POA. So remember, it's this idea of incapacity planning. It can happen whether, like I said, it's a coma, whether it's age-related decline, that you're not able to manage your finances. And if that is the case, somebody else may need to step in and do that for you. Well, if that's the case, then they need to have legal authorization to do that. So a financial power of attorney is going to give somebody legal authority to access your finances, access your bank accounts, and then it's also going to give them the ability to manage them for your benefit, right? Similarly, a healthcare power of attorney is going to give somebody the legal authority to make healthcare decisions, to authorize treatment, to have access to medical records if you're not able to manage your own healthcare. So, again, it's very important for this incapacity planning that we have the legal authority for somebody to step in and be able to do that, because if we don't have these documents giving somebody authority to do things for us, if we become incapacitated, then we have to go to court, and that's where we have proceedings like guardianship proceedings or conservatorship proceedings, because now the court has to appoint somebody to manage our affairs. And that is a much more complicated process, much more involved, more expensive, and it's something we can avoid by using these two fairly simple documents. Finally, the next kind of document you'll probably hear about, an advance directive. So an advance directive, and a lot of times you'll see, this is combined with a healthcare power of attorney, but an advance directive, we're directing in advance what type of healthcare we may want or what type of healthcare we may not want. And really, we're talking about healthcare at end of life. So usually the big picture idea is going to be in circumstances where there's a diagnosis of a terminal illness, or you'll hear people talk about circumstances where somebody's in an irreversible coma. Do we want all measures taken to keep somebody alive, or do we want to have somebody be able to authorize things like palliative care or hospice? So again, this is something where it's not dealing with transferring assets when you die, but it's still a very important part of estate planning. So keeping these 5 documents in mind, a lot of times the basic or one of the first questions people have is trust versus will, right? So in terms of looking at how we're going to transfer assets, transfer ownership once we pass away, trust versus will is sort of the basic question, right? And basically what I tell clients to think about, it's not always either or, right? Both of these documents are going to accomplish or get the job done, but it's a question of how do you want to get there, right? They'll both get you where you want to go, but how do we want to get there? So, as we said earlier, a trust may be a good fit for you if you want to avoid probate. Like I said, probate, any will has to go through probate, which is a court process. So sometimes that process can be a little complicated, especially if you have a more complicated estate. It does tend to take more time and require more sort of administrative maintenance than using a trust. So avoiding probate, typically, if that's a concern for us, the trust is going to be the way to go on that. Now, probate is, like I said, less of an issue. If we have a smaller estate, the estate is fairly simple, then sometimes probate can be very quick or abbreviated. So if we have a simpler estate, worrying about probate may not be much of a concern for us. I tell people it's always a good idea to talk to an attorney, get a sense of like what the probate process might look like for you, and that's going to help you decide, is a trust really worth it, or is the process going to be so simple that it's not really an issue for me. The other thing that trusts are good for is making arrangements for children, heirs with special needs, or again, incapacity. So keep in mind that children can't own property outright if they're under 18. So in that case, we may need to set up a trust. And by setting up a trust, we're going to have money set aside for children, but we're going to have somebody else come in as trustee to manage that trust. That's a good way of helping manage money for children until they reach the age where they're able to manage things on their own. So a lot of times, if that's a concern, we may want to start thinking about a trust because we need somebody to manage finances for a minor child. Likewise, if one of our heirs, somebody in our estate plan, has special needs, there are certain concerns there because receiving a large inheritance can impact resource-based public benefits like SSI or Medicaid. So sometimes if that's a concern, we may need to set up a special kind of trust called a special needs trust so that the money that we're giving this person doesn't negatively impact their government benefits. Likewise, a trust is also helpful in incapacity planning, and that's because when we set up a trust, we're going to have the trust manager or trustee, then we have the beneficiary, and so a lot of times when we set up the trust, you're, as the person creating the trust, both of these things, right? You're the trustee and you're also the beneficiary. But it can also happen that you remain the beneficiary and somebody else steps in to manage the trust for you. So in that way, trusts allow us to handle a certain amount of incapacity planning, and they're helpful in that regard. Another thing where a trust might be a good fit for you is when there's real estate in different jurisdictions. So think about, somebody who lives in Virginia, their home is in Virginia, but we have like a beach house in Maryland. Well, if we use a will, remember we have to go through probate, but realize because we now have property in two different jurisdictions, right? We would do probate in Virginia. We might also have to do probate procedure in Maryland to deal with the Maryland home. That's called ancillary probate. So what I tell clients is oftentimes one of the benefits of a trust is avoiding probate. We may really want to avoid probate if we have different real estate holdings in different jurisdictions. Finally, trust can be very important in high net worth estates where we're looking at tax planning. A lot of times that may not be much of a concern because we don't start worrying about estate tax until the value of the estate gets into the several millions of dollars. So for a lot of people that may not be a concern, but if it is, one of the ways we start planning to deal with those tax issues is by using trusts. One of the things when we talk about trust versus wills, one of the things that comes up is sort of ease of setting them up, right? We'll see that with a will, there's less upfront work. So a will, basically, once we create the will, you kind of set it and forget it. You store the will, put the will away, and then the will doesn't come out until the maker has passed away. With a trust, there is a little bit more upfront work. We call it the funding process. So once the trust is set up, remember, we're going to have to take our assets and put them into the trust. So that process is called funding. So that's a little bit more work than a will would have. So we're going to have to, for example, go to the bank, retitle bank accounts. We may have to, if we own real estate, have new deeds that transfer real estate into the trust. Now, remember, this may be worth it if we have a more complicated estate, so probate's going to be more complicated on the back end. So we do that work up front now, so that when the owner passes away, it's, we have less administrative bureaucracy to deal with. But some people don't like the idea of the funding process. This idea that, okay, we have to make the trust, but now we also have to start administering it. That can be less desirable for some people. So that's the basics of when we look at estate planning, what we're trying to accomplish, and how we use some of the more basic documents to do that. I always recommend working with an attorney. These are some very substantial issues we're talking about. We're talking about significant assets. We're talking about, there's a lot of legal and technical requirements. So it's always good to have an attorney sort of help guide you through that process, right? What I tell people is you don't want to be one of the people who gets something off the internet, set it up the wrong way, and now you're in the half of my practice where we're trying to fix a poorly created estate plan. A little bit of planning up front is going to save you a lot of headache down the road. So because of that, we try to make it really easy for people to work with an attorney, make it really easy and convenient to sort of put your plan in place. And these days with Zoom, I tell people, it's entirely possible for you to work with us, put your estate plan together, and not even have to leave your house, right? So here's our process. I'll kind of walk you through it. Basically, we have an initial call. This initial call is scheduled, if you go to our website, there's going to be a red button that says schedule a call. You can click on that button. A menu will pop up. You can pick the day and time, and then you'll literally be talking to me. We can kind of go through some of your initial questions and kind of set up the rest of the process. You can also call our main number, 703-249-9007. They'll schedule a call with me, and we can, again, we'll set up that call. We'll have the call and talk about getting the rest of the process in place. After we sort of go through our initial call, we'll set up what I call the design meeting. By the design meeting, you'll have received an intake form. So I'll have a better idea of the specific assets that make up your estate. We'll kind of, at the design meeting, sit down and we'll talk about, okay, what is our specific plan for, transferring everything? What is our specific plan for incapacity? What are the documents we're going to use? And things like that. At the end of the design meeting, we'll have a summary that sort of lays out everything that we're going to be doing in the estate plan and what documents we're going to be using to do that. And so once we've had the design meeting, we've got our blueprint for your overall estate plan. Like I said, our goal is to make the entire process as easy as possible. So we can do the design meeting via Zoom. We can do the design meeting via in-person meeting at our office. It's whatever works best for you. Once we've had the design meeting and set up that blueprint, we can then go over our, we'll prepare the documents for you. We'll go over the actual documents that we've created together and kind of answer questions, talk about revisions if needed, until we get to the point where the documents are finalized. When we send you the draft documents, we have like a little custom explainer video that goes through the documents that kind of walks you through what you need to look at when you're reviewing the documents. Once the documents are good to go, we have signing and execution of the documents. Again, we can set it up so that you come to our office, or like I said, we can have documents sent to you, make arrangements for you to sign at home, so you can get this estate plan put together without ever having to leave your house. So we try to keep the whole process accessible, easy to manage, and convenient. So hopefully, it's a very easy way of working with an attorney and getting a solid plan in place. So that's our introductory video. Like I said, please feel free to visit our website or give us a call, schedule your initial call. I'm always happy to talk to clients about how we can help them and answer questions about putting your plan in place.